Good day. I always say good afternoon, good morning, and I have no idea when you're watching it. So I'm just going to say good day, even if it's at night. Not legal advice, KNOT. Please like, subscribe, share, comment, ask questions. Happy to respond if you have questions too. So I'm going to do basically, I'm doing a video today on the dispute between Elon Musk and Mark Zuckerberg, and give you a little bit of kind of let's talk about the framework of the dispute, and then we can talk about more details at a later time. And I'm also going to talk about a couple of Tesla issues on top of that. But before that, we have the joke of the day. And what's the difference between a hippo and a Zippo? One is really heavy, and the other one is a little lighter. So, talking about Tesla now, there's a couple of things that are going on. Obviously, I'm a Tesla bull. I follow Tesla very carefully. I appear on Farzad Misbahi's community forum often on Fridays at 11 Pacific. And I follow Tesla pretty carefully. There was just a couple of things that are occurring in the near term that non-Tesla people might be interested in, or it might impact the company, it might impact the stock, even though this is not financial advice, of course. So coming up shortly, probably within the next quarter, the Cybertruck will be released. And to those who've seen it or not seen it, it's an impressive vehicle. You may not like it, but it's impressive and will catch people's attention. There's over 1.5 million reservations. Delivery will happen sometime in 2023. Tesla's earnings date is the 19th of July, so there might be an announcement of an event, a delivery event then. Probably not huge numbers in 2023, but in 2023, probably upwards, maximum 375,000, probably in the range, closer in the range of 200,000, will be a great stimulus to Tesla, because people are going to buy them, and it's going to create a lot of interest in Tesla, which in the past has also stimulated the stock. Not financial advice. Second part is full self-driving. I don't know if any of you are familiar with, but there's various levels of full self-driving. At level 4 and 5, in essence, the car is driving without the assistance of a human. Human doesn't need to be in control. In 2023, especially in recent months, Tesla has had the use of a supercomputer, Dojo, to enhance the process and expedite the process of full self-driving, which is a learning process. And there has been great advances. So all Tesla is down to now is the kind of the edge cases, the unusual cases, and then the way it would work is you solve one of those cases, it should translate to similar cases in other locations, geographic locations. I think that's how the learning process goes. But anyway, it's very possible that by the end of 2023 or sometime in 2024, that FSD will be fully implemented. It will increase the take rate, increase profits for Tesla, and they may also license it to other OEMs, which might make it more available and increase revenue for Tesla. I think these are happening in the near term, not financial advice, but just throwing it out, especially directed at people don't follow Tesla too carefully. Now, kind of like the crux of this video, on July 5th, Quinn Emanuel, which is the counsel for both Twitter, Elon, and I think Tesla, sent to Mark Zuckerberg and Threads through Facebook. Threads would be the new kind of competitor to Twitter that just came out. And counsel for Twitter sent the cease and desist letter to Zuckerberg claiming that Threads had misappropriated trade secrets and other intellectual property from Twitter. And this was accomplished in large part through former employees of Twitter who had left and gone to join Meta. And it's presumed for my discussion that all these employees had non-disclosure agreements or something like that, which prohibited them from using information, confidential trade secret information that they had learned at Twitter and using that in their new job wherever they went out. But notwithstanding that, it's difficult often to prove up trade secret cases. I remember one particular, I happened to, at one point in time, I do mostly real estate litigation, but at one point in time, I did do trade secret litigation, worked at an intellectual property firm. And I remember I had one particular trade secret case I handled. A lawyer claimed to have invented an electronic baseball video game, and my client, who was a video game manufacturer, I think in San Diego, California, that was in bankruptcy, and we represented the bankruptcy trustee. But they had come out with another video baseball game, and I remember in my office I had a version of the plaintiff, which was the opponent's video game, sitting in my office that I had to constantly play to understand all the features. And I remember that in essence, the attorney it was the inventor, the claimed inventor was an attorney also, by the way. He was in essence claiming that he had a unique idea as to baseball, even though everybody knew. So we had experts go through and compare and contrast various features of the games, and that's how we were determining whether they'd been copying of features and whether, in fact, there was a trade secret, etc. It was an interesting thing. Case ended up being resolved, some kind of resolution, I think through insurance, because you could have insurance theoretically that, at least at that time, that covered misappropriation of trade secrets. But also during that case, what was interesting also is the inventor of the game, who was the plaintiff, also had been convicted of securities fraud prior. And during our case, because of certain conduct that he undertook that was disclosed in settlement negotiations we had in federal court before a magistrate, the federal government started a probation revocation proceeding during our civil case on an unrelated case. But anyway, it was interesting though, because the issue was just kind of comparing and contrast features. So back to Elon and Zuckerberg. So in essence, Twitter is saying that Threads is a clone of Twitter, and that Threads or Zuckerberg or Facebook or Meta or whoever stole the features and value from Twitter's work product. And so when it comes to trade secrets or misappropriation or claims involving intellectual property, and intellectual property would include trade secrets, trademarks, patents, copyrights, all those type of things. But there's both state and federal laws that would apply. So you may be able to sue somebody and get enforcement under state law, but there's also a federal law that can apply. And most of these actions, and I would expect if this particular dispute goes to litigation, which I think is very possible, that it will go to federal court. And there is a federal statute that defines what a trade secret is, which I'll talk about in 1 second. There's also a 2016 law that was passed called the Defend the Trade Secrets Act, which grants to individuals and entities a federal private right of action to battle against misappropriation of trade secrets, which means in English that someone can sue in federal court to defend their rights. So under the act, kind of what are we going to do? So when you have a trade secret, what is a trade secret under federal law? And I'm going to not read the entirety of it, but this is in essence, this is what the case is. So a trade secret is all forms and types of financial, business, scientific, technical, economic, design, prototypes, etc. And it includes electronic, photographs, writing, any form. Any of that, if the owner of that has taken reasonable measures to keep such information secret, and the information that is secret has independent value derived from it being secret, and it's not readily ascertainable by others. So that's kind of the elements. It's the format, a type of record, something, as long as you use reasonable measures to protect it and it has independent economic value. Often the issue comes out to be the reasonable measures, but we'll address that in a second. The second hurdle And then, like I said, that often is the problem. So if you establish that you've developed some type of pattern, prototype design, let's say it's Twitter. Let's say it's Twitter. How have you protected disclosure? And let's say it's about certain features, because I don't know, we haven't got to that point in time, but the litigation may be about features, since that's my experience. So, um, how do you what do you have to do to protect those features in order to have a valid claim? Or what are some examples of ways you can protect your intellectual property that will satisfy? It doesn't have to be perfect protection, but ways you can do it. You can have a non-disclosure or confidentiality agreement. You could make documents confidential and trade secret. You can actually market on the documents. You could restrict disclosure access. You could train employees. You can have audit inspection teams look through documents, facility measures like locking cabinets, and you can have contractual obligations even at post employment, where employees are not permitted to disclose the information, use the information, etc. So you can have employment agreements. So let's go back up, and that's kind of where we started. So let's presume that employees at Twitter had employment agreements. Those employment agreements themselves can have a provision that has a non-disclosure agreement, that you can't disclose confidential information. It may be called a confidentiality agreement. And that can be within a employment agreement, or it could be a separate agreement, non-disclosure agreement, that can have separate consideration. In other words, you're paying something separately for that. So you might have a salary, and then for the non-disclosure agreement, you could get an X number of dollars. So you could have two separate agreements, and they're generally enforceable. So it's risky if you're, let's see, the person bound by that agreement, but you believe let's say it's your employer, breached some agreement, they didn't pay you severance or something, and let's say you go out and spread the information that's covered within that non-disclosure agreement. It's risky that you would be relieved of your obligation. So maybe your employer might owe you $5,000 and you owe them $1 million for disclosure. So it's interesting, and beyond that, just having that non-disclosure does discourage people from disclosing those type of secrets. So it has that impact by itself. So in California, just kind of use California as an example, just to kind of distinguish. So you can have a non-disclosure agreement, where basically confidentiality agreement, where you're not supposed to disclose information, and those can have more broad enforcement. Or a lot of times people have non-compete agreements. So you sign somebody up, and it could be like an equity partner who has an interest in ownership, or it could just be somebody who's an employee. But you might have a non-compete. So after they leave, basically it says you can't engage in the same business as the place you're leaving from for a period of time. And in California, generally, they're really strictly construed, contrary to like non-disclosure agreements. The non-compete agreements are strictly construed. If you're not a prior owner, it's very difficult or harder to enforce. And even if they're enforceable, they usually have to be for a limited time period, and in a limited geography. In other words, if I'm in LA, for example, I can't say you can't operate a competing business in the United States. It usually has to be within a certain mileage of Los Angeles. Let's say 50 miles of Los Angeles for 12 months, just making it up, as opposed to forever and the world. So again, just to distinguish, you can have a non-compete agreement and a non-disclosure agreement with regard to the claims that are going to arise in the Twitter versus Threads particular legal action, which I think is likely to go forward in light of Tesla and Twitter's change in philosophy to aggressively pursue their legal rights. I think it's likely that they'll proceed. And often, if it proceeds on, obviously I'll discuss it further, but it's interesting. You will see in legal proceedings, because I've participated in them, where you have confidential documents and they'll be marked as such. Access can be limited. In a deposition, you might have part of a transcript that's confidential and part that's not. In court, If there's jurors, they may be treated differently. There might be orders from the court as to them, sealed courtrooms, information provided to jurors that the public can't see, all those type of things. So the treatment is different, and once there's a case going on about confidential information, just because it's marked confidential doesn't mean it will be determined to be confidential. But in the interim, there's ways that that information like that is protected. So we're just at the start of these proceedings. It'll be a really interesting match. I know that before this, there was that nonsense about them fighting, but I think they may be fighting in court is really where they're going to fight. Or maybe they'll decide instead of litigating this, they'll fight. They'll have a battle, and whoever wins the lawsuit. But if it goes forward in court, and Quinn Emanuel is a very good law firm, obviously, most believe that these are still difficult cases to win. However, like I said, just by bringing the case, it does dissuade people from violating these provisions, makes them think twice, even if they think they're justified. So I will keep track of this because I think it'll be an interesting case as it goes. We'll see how it goes. Be well, take care, have a great day today.